Welcome back to the channel. Today we are diving into a really important concept in law and dispute resolution, that is arbitral tribunals. We'll break down what arbitration is, who arbitrators are, and why the number of arbitrators matters so much. By the end of this video, you will know exactly why an arbitral tribunal should usually have an odd number of arbitrators. Let's get started. So I have a question in front of me. This is a legal question. An arbitral tribunal should consist of a sole arbitrator, 3 arbitrators, an even number of arbitrators, an odd number of arbitrators, or any odd number of arbitrators, though if the parties continue with an even number of arbitrators, the parties are deemed to have waived their right to challenge a common award by such an arbitral on the ground that there was an even number of arbitrators. The correct answer to this is answer D, which is any odd number of arbitrators. Let's dive deep into each of these answers. So the correct answer is any odd number of arbitrators. Why? Arbitral tribunals are set up to decide disputes privately outside regular courts. If you appoint an odd number of arbitrators, that is 1, 3, 5, and so on, they can always reach a decision by majority. If you appoint an even number, that is 2, 4, and so on, you risk a deadlock. Two people may disagree with a no tiebreaker because avoiding stalemate is so important. The general rule is that a tribunal should consist of an odd number of arbitrators. Some legal systems go further and say the parties are free to choose the number, provided it is not an even number. Even where the law allows parties to proceed with an even number, if no one objects in time, that is a concept called waiver, the normal and recommended practice remains to choose an odd number. That's exactly what the option D captures. Now let us understand key terms. Arbitration. Arbitration is a private method of resolving disputes. Instead of suing in a public court, the parties agree, often in a contractual clause, to submit any disputes to one or more independent decision makers called arbitrators. Arbitration is popular in cross-border commerce, construction, technology, and many other fields because party autonomy. The parties design the process, that is how many arbitrators, what rules, where the hearing happens, and what language is used. There's neutrality and expertise. They can pick neutrals with subject matter expertise, for example an engineer for a complex construction delay claim. Confidentiality. Proceedings are generally private. Enforceability. Arbitral awards are widely enforceable internationally, example under the New York Convention, often more easily than foreign court judgments. Let's take an example. Two companies, one in India and one in Germany. They sign a supply contract with an arbitration clause stating any dispute shall be finally settled by arbitration seated in Singapore by 3 arbitrators under ICC rules. If a dispute arises, they don't file a lawsuit, they start an ICC arbitration. Let's look at the other term, arbitrator. An arbitrator is a neutral decision maker. Core qualities of an arbitrator are independence and impartiality, that is no financial interest or bias toward either party. Competence, knowledge of the field and of arbitration procedure. Availability, time to run the case efficiently. Arbitrators must disclose circumstances that could create doubts about their impartiality. Example, prior consulting for a party. Parties can challenge an arbitrator for lack of independence. If the challenge succeeds, a replacement is appointed. Example, in a 3-member tribunal, each party nominates one arbitrator. Those two then select a presiding or chair arbitrator. If they can't agree, an institution or court named in the clause appoints the chair. Let's look at the third term, arbitral tribunal. The arbitral tribunal is the panel of arbitrators deciding the case, either a sole arbitrator or a multi-member panel, commonly three. The tribunal manages the entire proceedings, sets timetables, rules on evidence, holding hearings, and finally issuing awards. A key doctrine is competence, that is jurisdictional competence. The tribunal may rule on its own jurisdiction, example, whether the arbitration agreement is valid, before a court later reviews any challenge. Fourth, sole arbitrator versus three-member tribunal. Sole arbitrator, that is the odd number, which is 1, it is faster and cheaper, suitable for lower value or simpler disputes, but the decision relies on one person's judgment and availability. Three arbitrators, odd number, which is 3, the most common full tribunal, offers checks and balances and combines expertise. Slightly slower and more expensive. Decisions are by majority. If one arbitrator disagrees, they may write a dissent. Example, for a $1 lakh consultancy fee dispute, may use a sole arbitrator for efficiency. A $100 million infrastructure delay claims with complex technical and legal questions often uses 3. Fifth, even versus odd numbers. Odd numbers, that is 1, 3, 5, guarantee a majority decision, eliminating deadlock. That's why many statutes and institutional rules require or at least prefer an odd number. Even numbers, 2, 4, and so on, risk of a tie. Some systems historically allowed 2 arbitrators with an umpire stepping in if they disagreed, but modern practice discourages this. In many jurisdictions, appointing an even number is simply not permitted. In others, it may be procedurally defective but waivable. Next, let's look at the waiver of irregularities. Waiver means a party loses the right to object to a known irregularity by participating without timely protest. In arbitration, if the law says don't have an even number, but the parties knowingly proceed with 2 arbitrators and litigate the case to the end without objection, a court may later hold that they waived the defect and cannot set aside the award just because there were 2 arbitrators. Option E describes this idea. It's a safety valve against opportunistic challenges after an unfavorable award. For example, parties A and B agree mistakenly on 2 arbitrators. They both appoint one, conduct hearings, and receive an award. If B loses and then argues the tribunal had an even number, a court may say you should have objected earlier, you waived that point. Arbitral award. An arbitral award is the tribunal's reasoned decision resolving the claims, like a judgment. It states the issues, findings, and orders, example damages, interest, costs. Awards are final and binding, subject to limited grounds of court challenge, such as lack of jurisdiction, serious due process violations, or public policy issues. Disagreement with the merits is not a ground to set aside an award. Next, should usually consist of. The phrase in the question is important. It does not ask what is possible in edge cases. It asks what an arbitral tribunal should usually be. The practical and doctrinal answer is an odd number, most commonly 1 for modest cases or 3 for larger complex cases. Hence, D is the best general statement. Why the other options are not the best answer? A sole arbitrator is common but not the only usual form. complex or high stakes cases frequently use 3. So answer A is too narrow. 3 arbitrators. 3 is indeed very common, yet small value cases often use 1. Saying 3 as the usual composition ignores the many routine arbitrations decided by a sole arbitrator. C. An even number of arbitrators. This is generally wrong in principle because even numbers create the risk of a stalemate. Many statutes and rules either prohibit even numbers outright or discourage them. Option E, odd number, but even number is okay if parties waive objections. This is a more nuanced legal proposition that can be true in some jurisdictions where waiver cures the defect. But the question asks what a tribunal should usually be, not what might be salvaged by waiver. As a general rule of composition, D is the crisp and correct answer. So, specifying an odd number in the arbitration clause, that is 1 for straightforward and low value matters and 3 for complex or high value matters. These are the practical drafting tips in the agreement. Name an appointing authority or institution, example ICC, SIAC, LCIA, to avoid stalemates in appointments. Third is to incorporate the seat of arbitration, that is the legal home, which determines the crucial law and courts that supervise the arbitration. And fourth is to choose the language and the rules, that is institutional or ad hoc, to prevent procedural uncertainty. The bottom line is, the safest and the standard design is an odd numbered tribunal, so a majority decision is always possible. Therefore, the best answer to the question posed is D, that is any odd number of arbitrators. Option E reflects a waiver concept seen in some laws, but it's an exception that does not change the usual recommended practice. So this completes the question. An arbitral tribunal should usually consist of what? A sole arbitrator, 3 arbitrators, an even number of arbitrators, and any odd number of arbitrators, or any odd number of arbitrators with a waiver option. So the correct answer for a tribunal, an arbitral tribunal, should usually consist of any odd number of arbitrators. Thank you for listening. That's it for today's video. We explored the basics of arbitration and why tribunals usually consist of an odd number of arbitrators. If you found this helpful, don't forget to hit that like button, subscribe for more legal insights, and drop your questions in the comments below. Thanks for watching, and I'll see you in the next one.